1 million Floridians have obtained licenses to carry concealed firearms because the legislature has made it legal to do so.
Mr. Davis, we understand the statutes that are applicable, but could you explain and help us understand how we can have Terry stops, which I know you're familiar with watching someone walk up and down a sidewalk and look into a window? That's not a violation of the law, yet cannot or could not engage a citizen when that officer sees a weapon, which we have to accept that they saw a weapon, a firearm, concealed in this case, which is a violation of law.
Well, in Terry, when you look at the facts of Terry, what you actually have is you have the officers observing them, not just looking in the window one time, but they look in the window, they go back, they confer, they then go back to the window, they confer, and they go back to the window. And the officer testified that based off his experience, he had reason to believe that a criminal offense was imminent. And it is in that.
But I mean, walking in the street, I can look in that window 100 times, and it's not a criminal violation, is it?
No, Your Honor.
Is the concealed weapon a violation on its face?
No, Your Honor.
It's not.
No,
the statute doesn't say that?
Well, the statute does list licensure as an affirmative defense, but the affirmative defense aspect of the license requirement deals with the trial burden of proof. And the Massachusetts Supreme Court, as explained in Massachusetts v. Contour, that has nothing to do with what the police are required to do on the streets. When you look at the statute, when you look at 790.06 subsection 1, every person that obtains a license to carry a concealed firearm has to keep that license on their person and must present it upon demand when approached by the police.
So if in this situation the officer sees a bulge and he also sees something sticking out, there's no other suspicious behavior, he goes over to him. At that point, under Popple, it's a consensual encounter, correct?
Yes, Your Honor.
Right. And he asks him, what does he ask him? He doesn't say, do you have a gun? He says what?
Do you have anything on you?
Okay. The guy says no. Now, if he had said yes, and then if the officer then asked, do you have a permit? And if he said no, at that point there's a crime. He can arrest him. Is that correct?
Exactly, Your Honor.
Now, is that what, I mean, I'm trying to figure out how police, seeing here, it's apparently the police officer was not concerned for his own safety. And when I ask about why the pat-down was occurring, was it because it was a pat-down pursuant to an arrest or a Terry pat-down for his own safety? But what would be, if we would agree with you, what would be the permissible thing that a police officer could or should do?
Well, this legislature has actually already answered that question for us in subsection 1 of 790.06. And under that statute, all the citizen who's carrying a concealed firearm needs to do is to produce it upon demand.
And if he doesn't, he or she can be, like it was left at home, like your license or something, he can be arrested and charged at that point?
Could be, but we also know that under subsection 1, there's also a civil penalty for actually having a license but not carrying the license on your person. So the next sentence after it says produce it upon demand, the statute actually says that if you don't produce it and you do have a license, then you're subject to a civil penalty of not more than $25.
So are you saying that the police were acting contrary to the legislature's scheme in this case?
Exactly, Your Honor. The legislature has already established how these police-citizen encounters should occur. The legislature was well aware of the concerns and the need to verify that a person has a license.
Well, but let me ask you. That
let's go ahead.
So under this statute, let me see if I understand it correctly. Anytime a police officer sees a bulge on a citizen, any place, and they believe that bulge might be a gun, the officer has a right to approach that citizen and ask them to see a permit?
Yes, Your Honor. And that's how every consensual encounter works. When the police do not have reasonable suspicion
But is that a consensual encounter if they're asking me for the permit? Isn't that more of a stop?
No, Your Honor, and the reason why it's a consensual encounter is because how it's being initiated. There is no show of authority. So the officer is actually just walking up to the citizen, one citizen, and asking, do you have a license? May I see your license? And what makes it not a consensual encounter is that if the officer were to seat the bulge and the person were to get in a car, the officer couldn't then get in his car and stop the car to determine whether they had a license.
What about, didn't they see a handle to the gun? It wasn't just a bulge. Didn't the officer here see the handle for a gun?
Yes, Your Honor.
Okay.
So the issue in this case is not whether he had reasonable suspicion to believe that he had a concealed firearm. The only question is whether he had reason to believe that it was illegal. And
Let me directly to that point. Let me focus on the question that the officer asked, because this starts off as a consensual encounter. Question is asked by the officer. Let me give you a hypothetical. What if the officer had said, "Are you carrying a firearm?" And the defendant had said no. Wouldn't the officer in that circumstance have reasonable suspicion that he'd been told a lie, and that would give him a reason to do the pat down and proceed? Because he's seen the gun, he knows he's carrying a gun, and if the inference would be quite reasonable that if the defendant lied about that, that means he doesn't have a permit to have it, and he knows he doesn't, and he doesn't want the officer to know he's got it.
Yes, Your Honor. Undoubtedly, under that scenario, the officer would have reason to believe that they're being evasive, and that would give the police
but let me
reasonable
suspicion. Okay, so then we come down to whether this question that's asked, which was not "do you have a gun," but are you carrying anything? That we get to what does that mean? Is that correct?
And if I just clarify, the question was, do you have anything on you?
Okay, I'm sorry. Do you have anything on you? We get to the question of what does that mean? And you're saying, if I understand you correctly, that the defendant hearing that, the officer is not going to believe or reason to believe that the defendant hearing that or the suspect hearing that is going to understand that would encompass any deadly weapon that the person has.
Yes, Your Honor. And had that argument been raised by the state at the trial court, then the trial judge could have actually made that factual determination of whether this vague and ambiguous question was enough to give the officer reasonable suspicion. But in this case, the state never made this argument in the trial court, and the trial judge, looking at these exact same facts, concluded that the only issue in this case was whether mere possession of a concealed firearm gave the police reasonable suspicion. The state never made this argument before the third, and the third issued its opinion on the issue that is currently before this court, and that is whether mere possession of a concealed firearm gives the police reasonable suspicion.
Well, actually, under the state's theory, it would be carrying a concealed firearm would give probable cause to arrest, and then it would be up to the citizen to produce the evidence. But I want to ask about Regoletto or whatever, the conflict case, this case. In Judge Sicklin's dissent in Regoletto, he talks about the fact that there were other suspicious circumstances. The guy wasn't just carrying the gun concealed. He was in some way recklessly displaying the firearm in such a way that it gave the person that saw this concern. In fact, he didn't want to give his name, although he identified the person, because he was fearful. Now, in that situation, it's not just the carrying of the gun, and I want, as Judge Sicklin said, it's the totality of the circumstances that give rise to the fact this isn't just some citizen leaving his or her office and then has the gun and goes into the car and the police all of a sudden are stopping. There's something else here. So in that case, what's the argument about why wouldn't that search or the pat down or whatever, the Terry stop be appropriate because there was something more than just the carrying of the gun?
Well, if the dissenting opinion, in that case, the analysis is correct. If under the totality of the circumstances, the officer had reasonable grounds to believe that the person might not have a license or might be engaged in other illegal behavior, which in that case would have been improper exhibition of a firearm, then that would have been enough. But in this case,
That's the Baptiste. That's the, in the majority opinion, banishing of the gun, and that's, I thought that they used that to actually distinguish the case, the 4th District, because we didn't have those facts. Is that not correct?
exactly, Your Honor, that is correct. So you have the majority viewing the facts one way, and then you have the dissenting opinion viewing the facts another way. But when you look in this case, we don't have an allegation that he improperly exhibited the firearm. All we have is that he was in possession of a concealed firearm, and you have the vague question that didn't establish anything of, do you have anything on you? Now, had the officer asked the question, and had the officer just been direct and came out and asked, do you have a firearm on your person? And Mr. Mackey said no, then we'd have evasive behavior that would establish that that Mr. Mackey might not have a license.
Well, what would he, and maybe you're saying it wasn't argued below, but I sort of hearing what Justice Kennedy is saying, do you have anything on you? Well, what is he thinking? He's asking whether he has drugs on him versus packing heat?
Yes, Your Honor, and this is why. When you look at the record, you have a narcotics officer who's patrolling a high narcotics area, who's looking at hand-to-hand transactions, hand-to-hand motions, and is looking for firearms, and he goes up to Mr. Mackey and asks him, do you have anything on you?
Don't you think that really means, and everybody knows what that means, that you have anything on you you're not supposed to have? I mean, even my kids, when I ask them, you got anything on you? They know. If there's something they're not supposed to have, they know that. Don't you think this defendant did?
Well, that's the problem, Your Honor. Merely possessing, simply having a concealed firearm would not necessarily be illegal. It's not like drugs. Like drugs, there are no circumstances where a person could lawfully have drugs on their person. But for a firearm, well, except for prescriptions, but in terms of marijuana.
What if the question was regular type of situation where the officer walked by him, saw blood coming out, just asked him, got a permit for that?
That would have been acceptable. Because under
that would have been acceptable.
Yes, Your Honor, because under 790.06 subsection 1, every legal person that has a concealed firearm has agreed to do just that. When
Okay.
asked for the permit to
so
present
let's
it.
take it one step forward. No. Then what?
Well, then under that circumstance, then the officer now has reasonable suspicion to believe that he does not have a license, and now he can proceed with a Fourth Amendment seizure.
What if he said, yes, I have a permit? What's the next step?
Well, then the officer would ask for it to be produced, and the person would be required to produce their license.
And if he doesn't produce it, doesn't have it on him because he doesn't have one?
Well, two options. The officer could check with Tallahassee to search the database to see if he actually does have a license, and if it turns out that he's actually licensed but is not carrying it with him, then
So the officer can, there is a facility, an officer can radio in to see whether this person has a license or not.
Yes, Your Honor, and the officer actually, in this case, Officer May, did do that after Mr. Mackey said that he didn't have a license.
If it turns out that he does not have a license, he radios in and the database says he doesn't have one, can the officer at that point in time arrest him?
Exactly, Your Honor. And by that point, at the point when the citizen says, I do not have a license, at that point the officer can conduct a Terry pat-down, retrieve the firearm, and then once he calls in and verifies that they don't have it, then at that point he can just do a full arrest.
What do we do with the question of whether the carrying of, having a permit is an affirmative defense versus the element, and how does that factor into the analysis of the 3rd District here? I'm struggling with that, so could you help me on that?
Well, the third district's analysis really looks at the affirmative defense aspect in a vacuum. The affirmative defense aspect basically means that just as you have the burden to produce your license when you first see the police on the street, you also have to produce your license at trial. And if you don't produce your license on the street and the officer arrests you, if you don't produce it at the pretrial hearings, and if you don't produce it at trial, then the trier of fact may rightfully assume that the license does not exist. All you need to do is basically pull out your card and present your card to prove that you have a license. And if you never do that at any point in the criminal prosecution, then that affirmative defense just basically says, then we can assume that you don't have a license. But that's completely different, though, with the police being allowed to approach a citizen that they see on the street with guns drawn or stop a car just because they see a concealed firearm. The police, under Terry and Delaware v. Prouse, the police must have individualized suspicion of criminal wrongdoing in order to stop a person. And the fact that licensure is an affirmative defense does not relieve the police of needing individualized suspicion that that particular person's possession of a
Let me ask.
If we look at this case, this is assuming it's not the high crime area, and the person with the gun, if they simply started to walk away, what would the officer's option be at that point? In this situation, officer observed what he thought was a gun, person just starts walking away. What can happen?
Well, if the person starts walking away before the officer has engaged in the key question, may I see your permit, then the person is free to walk away. Now, if the legislature would like for it to be otherwise, they could adopt a statute similar to that of Louisiana. In Louisiana, the citizens that have a concealed firearm, whenever they are approached by the police, they have an affirmative duty to let the police know, I have a concealed firearm on my person, and then they must submit to a pat-down and seizure and a temporary seizure of that firearm while the police determine whether they, in fact, are lawfully in possession. And that's not the law in Florida. And the law in Florida is that the 1 million Floridians that are carrying a concealed firearm, all they need to do is produce it upon demand when asked. And unless the legislature changes that, in order to seize a person under the Fourth Amendment, the police must have individualized suspicion of criminal wrongdoing. And if I may, I'd like to reserve the rest of my time for rebuttal.
Justice Labarga, did you have a question before?
That's okay.
Okay.
Thank you.
Good morning. May it please the court, Shane Burnham, Assistant Attorney General, appearing on behalf of the state of Florida. Third District Court of Appeal properly held that Officer May had reasonable suspicion based on the totality of the circumstances to conduct the investigatory stop.
Well, would you help us understand that under these circumstances is that in Florida, if you have a permit, having a concealed weapon is not a criminal event. And so the argument proceeds is that anyone who has a concealed weapon is subject to being stopped, unlike the Terry circumstance where there was suspicious behavior. And the officer was able to provide an articulable suspicion.
Yes, of course, it is legal to carry a firearm in Florida if you have a license to do so. And the facts of this case must be looked at in the context of reasonable suspicion. And here, the officer observed Mackey in possession of a concealed firearm on his person, walked up to Mackey in a consensual encounter, asked him, do you have anything on you? To which Mackey says no.
Is that the point that makes the distinction, you believe, for the legal outcome in this case?
Yes. We don't have mere possession in this case. Regalado involved mere possession alone. And in this case, we do have the officer's observation of the firearm. But we also have the consensual encounter and the lie that follows that. The lie goes the lie leads the officer to reasonably believe that the firearm was being carried unlawfully.
Did the state raise that issue in the motion to suppress before the trial court?
I don't believe the state raised it in the motion to suppress. The state argued below that it was concealed, and then if the firearm wasn't concealed, then the officer had reasonable suspicion that Mackey was carrying openly.
So it is legal in order to carry a firearm. An officer, in your view, when he sees a person carrying a concealed firearm, has right, more or less, ask the person.
Yes.
Kind of reminds me, when I was growing up and got my driver's license. Soaking wet, I think I was about 80 pounds. And police officers kept stopping me all the time to see if I had a driver's license. I didn't look old enough to drive. But that's kind of the same thing, isn't it? They have a right to stop you to see if you have a license to carry a firearm. That's what you're saying.
I think when you're checking for licenses when you're driving, that the facts of that situation is analogous to what happened in Delaware v. Prouse, where the U.S. Supreme Court has held that the random stopping of vehicles to check for driver's license was not enough for reasonable suspicion and was...
How does that differ here? The random stopping of people carrying a firearm just because the officer feels he's carrying a firearm. I mean, isn't that the same thing?
No, it's not the same thing, because in our case, we have a suspicion that is individualized and particularized.
Which is what?
Here,
Articulate that for us.
well, basically, the officer observed Mackey in possession of a firearm that is concealed on his person, and then you also have the lie. But based on those facts, the elements for the carrying of concealed firearm without a license has been met, whereas...
Well, so again, isn't just what Justice Labarga said or asked very appropriate here, is that law enforcement can then engage in essentially a stop of every citizen that may have a concealed weapon, whether they have a permit or not.
Correct.
And that's applied indiscriminately. And why does that not fly in the face of other Fourth Amendment law for random stops?
Well, I just want to clarify that the state's position is not that mere possession should be a bright line rule. The Fourth Amendment jurisprudence has always held that a stop should be based, or reasonable suspicion should be based on the totality of the circumstances.
Well, again, that's what I'm at. Would you articulate for me what those elements are in this case?
I'm sorry?
Would you articulate for us what those are in this case?
We have the officer's observation of a concealed firearm on Mackey, and then we also have a consensual encounter, which elicits the lie. So
is that what the police officer said, though? And again, because a lot of this is the totality of the circumstances, and I can understand that if it's consensual to ask, we have, a lot of us have concerns about people having firearms. Other lots of us don't have concerns. But for the citizens that do fear for gun violence on the streets, having a concealed firearm is a concern. So if the police goes up and says, are you carrying a gun? The citizen answers honestly, yes. At that point, if they say yes, would you agree they could not do a Terry frisk unless they said they feared for their own safety, and here the police officer didn't say that? They would just be able to consensually say, ask them, and then if they say yes, then the next question is, do you have a permit? I want to see it. And that's all part of the Popple initial encounter, not a Terry stop.
Well, because the officer observes that the person is carrying a firearm, you have the reasonable suspicion that he may not have a license to carry that firearm, and then you also have the fact...
Well, now you've just put something else in that is... So what you're really saying, if that's true, that when an officer sees a gun concealed, because you can't have it open.
Correct.
So he sees it concealed, which is the only lawful way to carry the gun in public, right?
Mm-hmm.
You can't carry it out like in a holster. He then has, because the state says most people don't have a concealed weapons permit, that officer, he or she, has reasonable suspicion that he's carrying that, she's carrying the gun without a permit?
Well, that argument was in our initial brief, which we had amended the statistics.
I'm asking you, what is it? We have to articulate a rule of law. Is it that the carrying, an officer observing a concealed firearm in itself is enough, not just for a consensual encounter, but for a second prong, or under your view, a probable cause that it is that he is carrying it or she's carrying it without a permit.
Well, our position, as I mentioned before, is it's not necessary to reach the issue of mere possession, but if this court does choose to address that issue, this mere possession can be enough based on the U.S. Supreme Court case, Adams v. Williams, the 11th Circuit case in Lewis, all of the other state and federal case laws cited in our brief, and it's also supported by the majority of the districts of appeal in Florida.
What bothers me about this, if an officer has a right to go up to you, ask about you, or they feel you have a concealed weapon on you, they ask you about it. But they don't have, if they see the next person and they believe they have a concealed weapon on them, they don't have to, they could just let them go. But they stop this person, they don't stop someone else, then, you know, is that really all the officer needs? Is to think that you have a concealed weapon on you and that's it, you can do it.
Well, according to the structure of the case law and making the fact that a valid license is an affirmative defense, then yes, mere possession can be enough based on the greater weight of the case law.
Mere possession is enough to give the officer a reasonable suspicion that he may not have a license. Is that what I heard you say earlier?
I misspoke. Not that he does not have a license, but it gives him reasonable suspicion enough for him to investigate to determine whether or not he does or does not have a license.
But wouldn't the way he would do that, the way to investigate that would be to ask if he has a license, wouldn't it?
That's correct.
That's not exactly what happened here, is it?
The officer asked, do you have anything on you? And in the objective standard, or according to the officer, that necessarily means, do you have something illegal on you, or do you have a weapon on you? The fact that
Well, you said two different things. You said, according to the officer, and then you said something about an objective standard. Isn't it the case that what we really would focus on in connection with that question is what the officer, a reasonable officer, in those circumstances would understand about the response, and whether a reasonable officer in those circumstances would reasonably understand the response to be a lie? Isn't that what we would be looking at?
Yes, of course. And in this case, a reasonable officer would construe Mackey's answer to be a lie.
But you didn't, that wasn't questioned in the trial court. You're coming up, again, I understand we can affirm for different reasons, but there's got to be something in the record. If this police officer said, when this guy said that, I knew that he was carrying and he didn't want me to know. Now, you could say, well, we should just assume that, but Mr. Davis is given, a reasonable thing. He's a narcotics officer, and, you have anything on you? You have drugs. So we don't have that in this record to know that.
Well, because he asked such a broad question that would necessarily encompass contraband or weapons, something that an objective officer approaching a person that is otherwise unknown to him at point blank range, that is what he necessarily means when he asks that question.
Let me ask you about the burden of proof here. Did the state have to prove beyond a reasonable doubt that he was carrying a concealed weapon that he did not have a permit for?
Because the possession of a permit is an affirmative defense, the state does not have to prove that.
Okay, so that's on the defense to prove up, right?
Correct, and Mackey does not contest that it is.
All right, now let me give you another hypothetical. There's an exception for carrying weapons in the open for things like hunting, fishing, camping, right?
Correct.
So if he's got that not stuck in his pocket, but it's out in the open, he's got a weapon out in the open. Can the officer engage someone with a weapon out in the open?
If it's If the factors demonstrate that it is for hunting or some other exception.
You look at the totality of the circumstances about where they are, what they're doing, appear to be
Correct.
doing, and so forth. And so he
Correct.
walks up and says, "Hey, what are you doing with a pistol?" And he says, "I'm camping, or I'm on my way to go camping." What happens then?
Well, if the circumstances indicate that he is on his way to go camping, then that fact would dispel an officer's reasonable suspicion that he's carrying.
So the state then to prosecute him or to try to say what he's got there is a crime, they have, what's the burden of proof?
To
Does the
prosecute.
state have to prove that he's carrying a weapon in the open and that he was not using it for camping?
No, it would be an affirmative defense, and so the burden would be on the defendant.
To prove that he was carrying it for camping? Okay.
Correct.
I
Okay.
realize that you say the defendant conceded this was an affirmative defense. The amicus does not. And I'm reading the statute. It says, subsection 3, this section does not apply to a person licensed to carry a concealed weapon. So we don't necessarily determine based on that for a Terry stop, that it isn't incumbent on the officer before he does or she does anything further. Again, when there's no other suspicious behavior, the person's not casing a joint, it's not 3 o'clock in the morning, where there's, and there's no, and this is important here, this officer had no fear for his own safety. And this is where we're concerned usually with Terry stop pat-downs, is the officer protecting himself. It says, so how is that, for the purposes of a Terry stop, no question, an affirmative defense? It just says it doesn't apply to a person licensed to carry a concealed weapon. I mean, I could make an argument that it is therefore incumbent on the state to first find out if the person has a license before they make an arrest.
Well, we know that it's an affirmative defense because the exception is contained in a separate subsection. That indicates that it is an affirmative defense. Second, we have the standard jury instructions state that the state must prove 2 elements, that the firearm is concealed and that it is a firearm that is carried on or about a person.
We always say, though, the jury instructions are put out, and what we might require for proof of how we are going to allocate the burdens, we're now talking about citizens who are otherwise doing nothing wrong, under the state's theory, really being able to be stopped, being able to be frisked, and then produce evidence that they have a license to carry, and if they don't, being arrested. And we just, before we take that step, I want to make sure that we're effectuating the legislature's intent as to what the crime is and who has to do what under the circumstances.
Well, it's clear that the legislature intended that it is an affirmative defense.
You say that, but Ohio has, or Louisiana, one of them, says they usually know how to say affirmative defense. I don't know that it's clear. I mean, we may interpret it that way, but I don't see how you can take that language I just read and say it's clear that it's an affirmative defense.
Well, basically, under 790.06, the legislature has placed the burden on a gun holder to present a permit on demand. And as I mentioned before, it is contained in a separate subsection. We have the jury instructions. We have the 4th DCA in Watt, who also authored Regulato, that says the carrying of the license is an affirmative defense. And then we also have 790.02, which the legislature states that carrying a concealed firearm is a breach of the peace. All of these factors go to show that the legislature intended the carrying of the permit to be an affirmative defense.
Let me just, while we're talking about affirmative defense, whether it is or not, assuming it is, walk me through the procedure. Police officer stops me, carrying a concealed firearm, asks me for my license to carry it. and I tell them I have one, but I don't have it with me. I left it in my other wallet at home, whatever. What is the procedure then? What happens?
At that point, the officer might check the centralized database to see if he did in fact possess a
Well, let's
a
assume
license.
for a second that the officer does not have access to the database, doesn't have his radio with him, he's out walking. Can the officer arrest me? Can I be booked in the county jail for this second-degree felony? Is the carrying a concealed firearm a second-degree felony or third-degree felony?
It's a felony in the third degree.
Third degree? Okay, it's a third-degree felony. It's just, can he book me in the county jail for carrying a concealed firearm, third-degree felony?
Under those circumstances, I believe that he can, because it's your burden to produce the license. The legislature had made clear.
So I, law-abiding citizen who happens to have a firearm, who has a concealed firearm permit, I just happen to have left it at home that particular day. I'm going to be booked in the county jail. I'm going to have to bond out of jail, and then the state attorney could charge me. And to whom when do I present this permit? Is it a trial as an affirmative defense like we do in other cases, or driver's licenses, for example? If you leave the driver's license at home and you get cited for not having a valid driver's license, one can go to the clerk's office and show it to them, and that particular citation is dismissed. Is there a procedure for doing that here? Pay the $25 or whatever it is later? How does that work?
I'm not quite sure at what point in the proceedings a person can present their permit and have the cases dropped. But going back to that situation, I guess the officer could always radio another officer, as it was suggested before.
Well, there can be some dire consequences by an officer stopping someone, and even if a person has a permit and not have it with them, there can be some dire consequences. And what happens to that person? You can have a bad day, very bad day. Be booked in a county jail and those kind of things. I don't know. Is that the way it works?
I suppose so. If this court does not have any questions, I see that my time is almost expired, and I would just ask that this court approve the Third District Court of Appeals decision. Thank you very much.
Thank you for your argument. Rebuttal?
Is that the process as you understand it, the way it's been described, that if you don't produce a license, you can be arrested and booked in the county jail and charged with a third-degree felony, and later on the affirmative defense is produce a trial?
Well, that's not really the process, because the officer would have access to the database. Just as, he could check your license or anything else, he could just sort of go to the system and verify whether you in fact had a license. Now, of course, if it turns out that he doesn't have a license and the Department of Agriculture does not show that he has a license to carry a concealed firearm, then under that circumstance, he would be arrested.
But even if the officer didn't have access, wouldn't he actually check that once you got to the police station?
Yes, Your
I
Honor.
would think.
Yes, Your Honor. Or more likely than not, if I were arrested, you get someone to bring the license to the arraignment so you can present it to the court, and more likely than not, you can move
I would think
to
you
dismiss
would
it.
try to do it right there at the police station before you go through all that fingerprinting and all the other things.
Exactly, Your Honor.
Isn't the real problem also that we're concerned that there's going to be selective enforcement? And I don't really see you arguing that, but, I think about where this is most likely to be used versus other places, and how does that factor into our consideration here?
Well, actually, that's why this case is just like Delaware v. Prouse. Under the state's argument, all 1 million Floridians who are carrying their concealed firearm, anytime they're carrying, they can be stopped, seized, and possibly arrested. And under Delaware v. Prouse, the U.S. Supreme Court concluded that you do not stop people to verify whether they are following the law. You stop people because you believe they are not following the law.
Well,
and
we have, our U.S. Supreme Court seems to consider the location as one of the factors. Not whether I agree with it, but it's a question what the law is. Someone running in a high crime area creates certain circumstances that our U.S. Supreme Court, although I may not agree, have said that that has to be factored in with regard to whether you can stop the individual, hasn't it?
Yes, Your Honor.
And so here I understand that I mean, you know, courts, whether it's appropriate or whether I agree with it or not, I have to follow what the U.S. Supreme Court tells us, correct? And if they identify, I mean, this happened in what they say in the opinion was in an area of drug and crime. So, I mean, does that make a difference? We're talking about, is this selective enforcement or is it parts of geography? How does that fit in?
Well, the testimony was that it's a high narcotics area, and there was actually and there was actually no evidence in this record that this is an area where people tended to have guns and weren't licensed.
Well, I mean, isn't that being a little naive? In areas where there's narcotics, there's no weapons. I mean, please. I mean, isn't a pretty violent area when you're dealing with drugs and those kinds of things, isn't it? Isn't that common sense?
That could be an understanding of the record. But I mean, if that were the case, then basically the police could stop anyone. I mean, even they could stop under that same argument. The police could stop someone that was driving because this is a high crime area. People tend not to have licenses.
Well, no, but it is a factor, is it not? I'm not saying I agree with it, but I mean, has the Supreme Court told us that we look to that as one of the elements?
Yes, Your Honor, that is a factor. But when you look at the facts of Wardlow, you had high crime area plus headlong flight, unprovoked headlong flight. So the idea was that when you have someone who sees the police, and this is an area where people are always committing crime, and a person actually sees the police and takes off running, then the officer has reasonable suspicion to believe that they're running for a reason. In this case, you don't have that. You just have that this is a high narcotics area, and the person doesn't have any drugs. The person isn't engaged in any suspicious behavior related to the type of crimes that he's looking for. So yes, the area would be considered, but you don't have that in this case. But all you have here, this is really just a Delaware v. Prouse situation. And in Delaware v. Prouse, the U.S. Supreme Court concluded...
If you were out of time, if you could conclude your...
Yes, Your Honor. In conclusion, this case is basically just like Delaware v. Prouse, and for that reason, we'd ask the court to reverse the 3rd District's decision, because under the 3rd District's decision, all 1 million Floridians can be stopped anytime they're carrying a concealed firearm, and that's inconsistent with the individualized suspicion requirements of Delaware v. Prouse. Thank you.
Thank you for your arguments.
May I inquire?
Please.
Is this your all's first time, both of you, in this court?
Yes, Your Honor.
Well, I think you both did a great job. Makes me proud to be a lawyer.
Thank you, Your Honor.
Thank you very much for your arguments. Court is adjourned.